morning and welcome to the Court of Appeals. I want to take just a moment before we get started and run over the procedures that we're going to utilize today. I know we've got experienced practitioners out there, and I know you probably already know this, but I do this for my benefit more so than anybody else's. If you are the appellant and, well, each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, please do that after you've come to the podium and introduced yourself, but before you begin your oral argument. You may reserve up to 5 minutes of rebuttal time. We have a lighting system on the podium. We believe it to be very straightforward. There are 3 lights, green, yellow, and red. So long as the light's green, you got plenty of time. Light turns yellow, you are running out of time, and when the light turns red, you are out of time. We ask that you please respect those time constraints. Probably one of the most important things you need to know is this. These arguments are being live streamed. Most of you, all of you, I'm sure, understand that. But the important part for us is once you say it, it's out there, and you can't take it back. So we ask that you please think about what you're saying before you say it. I'm sure you will, but sometimes you get caught up in the heat of the moment. Your panel today consists of Judge Neil McBrayer from Nashville, Judge Jeffrey Usman from Nashville, and I'm Steve Stafford from Dyersburg. Miss Ashley, anything we need to take up before we call the first case? You may call the first case, please.
Sandi Dawn Cunningham et al. Versus Bryan Truckline Inc. et al.
Good morning.
Morning, Your Honors. My name is David Grimmett. I represent the appellants in this case. I'd like to reserve 5 minutes for rebuttal, please.
All right, sir. You may proceed.
Thank you, Your Honor. And may it please the court. My name is David Grimmett. I represent the plaintiffs. In this case, it's a very simple case as far as the facts, but the underlying law and how to apply that law is somewhat complicated compared to what the trial court did in this case. In this particular case, on the morning of June 19th, 2016, a tractor trailer was driving through Dickson County, at which point it broke down. How it broke down is a question of fact because we really don't know. The defendant claims that he ran over a tire tread and had to pull over, but we also have evidence that says that there was no evidence of a tire tread strike. In either case, he had to pull over on the side of the interstate on I-40, facing east. Those are the facts that we know. That was approximately 12:30 a.m. For the next 7 to 8 hours, that tractor trailer was parked on the side of the interstate, and the defendant driver was consistently contacting the defendant company saying, "Hey, I'm stuck on the side of the road, can you please help me?" Hour after hour after hour went by. At approximately 3 o'clock, a mobile mechanic came out to the defendant tractor trailer and tried to fix the engine. He did not have the proper equipment, so he had to leave. Again, hour after hour after hour passed. Now this is the interesting part, the actual geography of where the accident happened. Because at the same time, all these events are occurring, we have the decedents and their father and Mr. Lawrence Reddick, who is camping, celebrating for Father's Day. They are packing up, they're getting in the vehicle, and they're driving along I-40 at approximately 7:30 to 7:55 because the accident happened around 7:55 that morning. They're driving along, at which point a bee flies into the vehicle. Now what's interesting, and what the trial court relied upon, was the trial court found that the truck, the tractor trailer, was visible from a mile away. But that is the question of fact. As we all know, in a motion for summary judgment like we have here, any questions of fact must be taken in a light most favorably for the non-moving party.
Counsel,
Yes, Sean.
in terms of, I want to draw a distinction here in terms of visibility could be seen and was actually seen. And it's my understanding that the truck was not actually seen in this case, of general agreement that the driver didn't see it until the end, the B, but could be seen in this case. What are the facts that suggest this truck could not be seen from a mile and a half away?
Specifically, we have the testimony of the passenger. And if you look at the testimony, and both parties refer to that, and I'm going to read to you exactly what the testimony was. During his deposition, Mr. Reddick testified as follows. Question, were you looking ahead in the roadway before the B incident occurred? Answer, yes. You didn't see the tractor trailer up ahead of you on the right? Answer, no. Did Mr. Isabel see it? Answer, no. We were going around a pretty good curve. Question, you were saying that before where the truck was there was a big curve? Answer, yes. Before we got to the truck, it was a pretty good, probably about as big as you can have on the interstate going around. Now that's the question that we have before your honors. And that was the question that we had at the trial court. Was the truck visible? One person says, well, you can see it from a mile away. The other person says, no, there was a big curve going around and you couldn't see it. When you have a question of fact, you have to take in the light most reasonably for the non-moving party, which is exactly what we have here. Now, using these facts, it's interesting because both parties rely upon a case called Carney, and what we're going to deem as the Carney rule, because that's kind of what we are all claiming. What's really interesting is that Carney would have reversed the trial court. In Carney, it involved a case in which the defendant broke down and pulled over to the side of the road. And then another car was coming along. And then the third vehicle was coming along. The third vehicle had Carney as a passenger. The second vehicle stopped abruptly to not hit the first vehicle. And then the third vehicle ran into the second vehicle. Trial judge in Carney dismissed both defendants. Carney sued vehicle number 2 and vehicle number 1, the one that was parked on the side of the interstate. Trial court dismissed it. Court of Appeals reversed as to vehicle number 1, the one that was parked on the interstate. The one that was parked on the road. And specifically, in Carney, the verbiage is, did the driver running into the standing vehicle see it in time to enable him, by use of due care, to avoid the collision? If he did not, his negligence is merely a contributory cause. If he did, his negligence is the proximate cause. In this case, we have facts to show that the driver, Mr. Isabel, did not see the vehicle because of this curve. That is the question of fact.
But was Mr. Isabel exercising ordinary diligence at the time? I mean, if he's swatting about a bee, it strikes me that he was not.
And that would be why Mr. Isabel is also a defendant on this case. But the ultimate question is, should the defendant that's parked on the interstate also be a defendant? Because again, this is a big curve that's coming around the interstate. And this is a very dangerous situation. In fact, the defendant 30B6, 30.026 representative even said that this is probably a hazard. One of the arguments from the defendant is that we can't guess about possibilities, coulda, woulda, shoulda. But we have testimony from the defendant stating that this was probably a hazard. Now, of course, we have multiple cases that the defendant has relied upon. We have federal cases. We have Kellner, Underwood, Humphrey, Hamrick. All these different cases that the defendant and the trial court relied upon.
And counsel, you wouldn't disagree that the federal cases have taken a could have been seen approach rather than did see approach. So if if the federal courts have been right in terms of their understanding of Tennessee law, then this becomes the pure factual question in terms of whether it could have been seen.
Absolutely.
From the distance.
It's interesting because the federal cases have in fact, I think there's even one where we say, we don't know what the defendant driver actually saw. Instead, we know what he could have seen. And that particular, but that's different from what Carney actually said.
Why is that the wrong approach? And common law develops, it evolves, and the federal courts have taken an approach of understanding Tennessee law as being a could have seen rather than did see approach. Why is that the wrong understanding for approaching negligence in this type of circumstance? And why isn't it non-negligent as a matter of law if a driver could have seen you from a significant distance and hit you on the side of the road, and maybe you shouldn't have been on the road, but as a matter of law, we don't expect people to run into vehicles that they could see from great distances.
But I thought about that, and the problem is that what could have happened, and given 20/20 hindsight, is a great power. It's just kind of like if I thought you all were going to fine for me, then I wouldn't be up here arguing. But what could have, would have happened is one thing. But here we have a situation where we have a distinct question of fact, and either way, it should be presented to the jury, not decided as a matter of law. And in every single case, if you look at Kilner, the plaintiff had an extended, unobstructed view of the tractor trailer. Was that the case here? Absolutely not. Underwood, defendant truck driver testified nothing obstructed his view of the parked vehicle. Did anything obstruct the parked view, or the view of the vehicle in this case? Yes, the curb. Humphrey, deceased could plainly see the rig on the side of the interstate, i.e. plainly visible to the driver approaching the rig, and couldn't determine what deceased saw, but able to see what others saw. Here, what evidence is there that the defendant, who do we have best? We have Mr. Riddick, who is not a defendant in this case, who testified from that testimony I showed you and said they did not see the tractor trailer until the very last minute. That is the question of fact. And that is why this case should be reversed, because it's a case that the facts should be given to the jury. And the jury should determine, a Dixon County jury should determine, the geography of that case, what the people saw, and whether it was a dangerous situation. Given that, it should be reversed. And I see I have 7 seconds left, so I'll reserve the rest of my time for rebuttal.
Thank you.
Thank you.
Good morning, Chief Judge Stafford and the rest of the panel. My name is Carl Brown. I'm a member of the Nashville Bar, and I'm appearing on behalf of the appellees, James D. Jones and Bryan Truckline. The arguments you've just heard from the appellant are the same arguments that have been made in these cases involving the Carney Rule for 70 years. And in all of these cases, 80-plus sites in Westlaw to Carney, the result is always the same, or predominantly always the same, which is that the rule in standing vehicle accident cases for determining duty and proximate cause, and especially foreseeability, is that it is unforeseeable as a matter of law that someone would drive into a plainly visible standing vehicle. Now, to address what the appellee just mentioned about visibility, there's no evidence in this case of a curve other than the testimony of the passenger, Mr. Riddick.
Why isn't that enough as a matter for summary judgment? I mean, if there's a witness who says there was a curve, I didn't see it, I couldn't see it, why isn't that enough to create a material dispute as to a fact that's critical for the legal standard that's being applied?
If that was the only fact, then I would agree with Your Honor. However, due care and foreseeability are the critical components of Carney and the Carney Rule. And let me just read.
But do you get that far? do you get past the disputed facts?
Yes, Your Honor. Let me
How
just,
so?
let me read David Isabel, the driver's, own testimony in this case. In Record 4, page 561, he says, "I can tell you exactly what caused the accident." This is his own words. "There was a bumblebee in the truck. He went off in the defrost vent and then he came out. And when he came out, he sat right in front of me on the windshield. I smashed him, grabbed him, threw him out the window, and then all hell broke loose after that. I really don't remember much after that." Then he's asked, "What were the weather conditions?" He said, "It was a nice morning, very nice morning." Then he was asked, "So where was the sun in relation to where you were?" "That I can't answer." "How fast were you going?" "I would estimate between 72 and 75. I had cruise set. I told everybody we were just going to take it easy and cruise to the house. There wasn't no traffic." Question, "Do you know if there was a curve?" Answer, "Like I said, I don't remember a curve. Maybe a small sweep." I guess you would say, a curve is a bigger word, Those are the exact testimonial words of the driver of the vehicle. And I want to address Your Honor's point. Carney is all about due care and foreseeability. Driving distracted is by definition not the exercise of due care. The Carney rule says if in the exercise of due care, that's the important part of this one line of cases, that Carney reconciled. If in the exercise of due care, you could have seen the standing vehicle, which in this case was completely off the roadway, then you hit it anyway, then you're a contributing factor. However, if in the exercise of due care, you could have seen it, but you didn't, then you're the proximate cause and the sole proximate cause. That's the test. It's whether or not in the exercise of due care, you should have seen it. And if you should, and you hit it anyway, then you're the sole proximate cause. That's what all these cases say. And Kellner is the most factually on-point case. In terms of the amount of time that this truck was on the side of the road, which I will say the evidence is clear, it was way across as far as it could go until it would have dropped off an embankment. It was not in the travel lane. In Kellner, the truck was there for 5.5 hours. The court held that was not an issue because in Tennessee, there's no law about how long a standing vehicle can stand in the lane. However, there is a Tennessee statute that says that cars will be removed after 12 hours of being unattended. The state patrol says they don't remove or tow cars until they've been there for 48 hours. So the 5.5 in Kellner versus the 7 in this case are exactly the same. And as a matter of...
You mentioned we have 70 plus years of jurisprudence, 80 something sites. Carney itself seems to use the language of actually saw. The federal cases could have seen. Is there any Tennessee precedent, any that you would point us to post-Carney that uses the could have seen language? Or is it really just a question of whether the federal cases are correctly applying Carney?
Carney specifically says, and it's interesting, Carney, as described by the appellant, is not distinguishable from this case in terms of the result, because in Carney, the woman who was parked that caused the initial problem was parked illegally. And the distinction in a lot of these cases is, in all of these federal cases, interpret Tennessee law and do an exhaustive review of Tennessee law in reaching their conclusions. But in Carney, the woman was on Nolensville Road. She parked in front of the gift shop. In 1951, in her Plymouth coupe, she parks in front of the gift shop and she is blocking a part of the northbound lane. There's traffic coming from south, and then you have a northbound lane on Nolensville Road that she is blocking That's one of the distinctions in these cases. Whether the vehicle was completely off the roadway or whether or not it was illegally parked or somehow blocking the roadway. Ms. Stamper was blocking the roadway. Now, along comes the Warren Brothers truck with Goodman driving. He was able to see her and stop in time. The Carney truck, where Carney, the plaintiff, was sitting against the back of the cab with a hot tar kettle in front of him, didn't stop in time, and he said it was because it was slick. For some reason, they oiled the roads back then, and the road had just been oiled, and he couldn't stop because it was too slick, he said, and he didn't see the Warren Brothers truck in time. The court found that, yes, Ms. Stamper, who was parked illegally, our driver was not parked illegally, Ms. Stamper was parked illegally. She was the main contributing factor because she blocked the road. The Warren Brothers truck is our driver. He was able to stop in time. He exercised due care. The truck behind, the court found, did not exercise due care.
That's what I'm wondering about those. Are there any Tennessee state cases post-Carney that do embrace the could have seen rather than did see approach? And is there, and maybe this is just a question of, are the federal courts interpreting Tennessee law correctly? But I'm curious, is there any Tennessee precedent post-Carney that you can point us to that says Carney's about whether it's, yes, they said saw, but it's really a could have seen standard? Are there any cases you would point us to in Tennessee that say could have seen rather than saw?
Well, I would point you to the Sixth Circuit case. I know it's not a state case, but in the Sixth Circuit case of Kellner versus Budget Car, the court specifically pointed out, and I don't know about this could have seen versus did see, because the issue is foreseeability. That is the primary issue in proximate cause. And in that case, could Mr. Jones, who had parked his vehicle safely on the side of the road, yes, for 7 hours, but 7 hours means other traffic was easily able to pass him if they were exercising due care. Most of that was overnight. Everybody saw him for 7 hours. Now, could he foresee? This is the question the courts ask. It was not foreseeable in our argument to James Jones that David Isbell would carelessly and recklessly disregard his passengers and become distracted by a bumblebee while driving over 70 miles an hour and crash into his plainly visible vehicle. It was also not foreseeable that David Isbell and his family were on this camping trip smoking marijuana throughout the whole trip and hours before they left. It was also not foreseeable to James Jones that David Isbell would leave 2 lanes of travel, cross over the white fog line, the rumble strip, and then go even further into the emergency lane and hit Mr. Jones's rig. All the cases say there's got to be foreseeability, and foreseeability is the primary factor in these cases, because if it's not foreseeable, and the courts constantly point out that, and let me just find it in my notes, this is in Kellner, and it applied the Carney rule stating, quote, appellant's broadly construed notion of foreseeability leads, however, to logical absurdities and fails to comport with Tennessee judicial precedent. Thus, under the appellant's scheme, a driver legally traveling in her own lane who is hit by another vehicle that crossed into that driver's lane could be held liable for negligence because it was foreseeable that vehicles leave their lanes of travel. That's the illogical result that would occur even under the normal rules of proximate cause and foreseeability. If Mr. Jones is charged with having to foresee the activities of David Isbell in smoking marijuana and being legally impaired at the time of the accident, being admittedly distracting and saying the cause of the accident was trying to chase this bee down, and then also foresee that he was going to travel across 2 lanes, the fog line and the rumble strip, and then hit him, then he becomes an insurer of all the other motor safety.
One of the things that the court said in its order was that from the direction in which defendant Isabel was traveling, it is undisputed that the Freightliner, the four-way flashers, and the warning triangles were all clearly visible from at least a mile away. Where does that come from, that statement? How do I know that that is undisputed? I mean, from this appeal, it certainly doesn't sound like it was undisputed, but is there a response to one of the statement of material facts from where that is gleaned?
The way appellate responded to our statements of undisputed fact on visibility, if you look in the cite that they give to the record, they did not dispute the visibility. What they did was they objected. Instead of disputing it, they said, objection, this fact is irrelevant. Drivers are not required to see 1.5 miles ahead of them. Most good drivers look at least 12 to 15 seconds ahead, which is a quarter mile. In Tennessee, the test is not what was generally visible, but rather what the driver actually saw. And that completely misstates Carney, but they're not disputing it. But to further answer your question,
so how was the statement phrased that they objected to? What was the specific statement that was made?
The first one was, I'm sorry, Your Honor. There were 3 visibility questions. I don't want to run out of time before I give. Can I just give you the testimony of the trooper that establishes it too?
Sure.
Okay, the testimony of the trooper at the criminal trial of David Isbell, and he was indicted and convicted of driving while impaired, vehicular homicide, all things that could not be foreseen by Mr. Jones. But the question was, I asked him what happened, and he told me that he and the front seat passenger, a beef had flown into the vehicle, and he and the front seat passenger were trying to I guess, swat it and get rid of it. And he didn't even see the truck before he hit it. Now this place by the mile marker 173, what were the road conditions there that day? It was a bright sunny day. Traffic on Sunday morning through there, it's I-40, so it's heavy, but it's probably what I would call light to moderate, given it's I-40. Is it curved or straight? Very straight, sir. How far could you see that tractor trailer truck from? I had a visual on it almost as soon as it got onto the interstate from 172. So I would say at least a mile and a half. So just to answer the question, there is evidence in the record to support that it was visible. But that's not a question of fact.
Isn't it a question of fact whether there was a curb or not? If there's a witness who says there was a curb, biggest curb you've just about ever seen, and the officers know it was straight, that sounds like a factual dispute.
It would be if David Isbell had not admitted total distraction and total lack of exercising due care. Maybe. But the question is, could Mr. Jones have foreseen that? Mr. Jones couldn't have foreseen this sequence of events, and that's what the Carney rule says. Foreseeability has to be reasonable. It can't be so absurd that anything a motorist does is the responsibility of the tractor-trailer driver who's parked legally off of the roadway. That can't be. That makes the driver of the tractor-trailer an insurer of all motorist safety, regardless of their lack of due care, inattention, crossing lines over into the emergency lane, hitting the truck. You simply cannot charge that tractor-trailer driver who is not illegally parked, who did put out the triangles, and that's undisputed, and put his four-way flashers on, and stayed with his truck and didn't abandon his truck. There is simply no way to charge him that he could have foreseen that unlikely amount of events on behalf of David Isbell. And foreseeability and due care are the clear questions here as far as proximate cause. Proximate cause is the question. I'm sorry. Thank you, Your Honors.
Your Honor. Your Honor, can I have a moment to fix the podium mic?
Yes, please. Go ahead. You may proceed.
Thank you, Your Honor. As far as the actual distance, let's look at the questions of fact. As we all know, when we submit a motion for summary judgment, we have to submit a statement of uncontested facts. Here in the record, at volume 5, page 618, is the question of fact. They submitted the following. From the direction in which the defendant Isabel was traveling, the Freightliner's four-way flashers and the warning triangles placed by the defendant Jones were all clearly visible to approaching motorists from approximately 1 mile away. That is exactly what Your Honor was asking about, but let's see what the response was. The response was, objection, this fact is irrelevant. Most drivers look at least 12 to 15 seconds ahead, which is a quarter mile. That's under the CDL. In Tennessee, the test is not what's generally visible, but rather what the driver actually saw. That's under Carney. But then we added additional facts to contest that. We said, defendant Isabel and Mr. Reddick both testified they did not see the truck until immediately before the collision. Additionally, defendant Jones testified that the truck was facing east and the sun was shining in his eyes, and more than likely shining in defendant David Isabel's eyes at the time of the collision. Now what's interesting is we're talking about how all these other cars did not crash into this tractor trailer from approximately 12:30 until 7:55. What is the condition that changed during that time? What is it that rises in the east every single morning as you're traveling east? What is it that would be visible in front of the driver?
What is it that the driver said he did not even see? I mean,
You know, it's-
how can you, 7:55 in the morning in the summer, and the driver says he doesn't even know where the location of the sun. I mean, that would hold a little more water for me if the driver had testified, oh yes, of course I remember the sun, it was right in my eyes, but you know, he was able to dispatch a bee, throw it out the window. Yeah, I mean, I just don't see the rising sun really being an issue here.
And I understand, but then the ultimate question is whether this is a hazard. Is it a hazard? You know, defense counsel argues that he cannot ensure something from a coulda, woulda, shoulda. But what did the defendant actually describe the incident as? On page 717 of the record in volume 5. And this is their response, their statement to our question of fact. Their response was, Bryan Truckline stated it could probably be viewed as a hazard if it's off to the side of the road, in quotes. Further, even if a truck parked in the emergency lane, quote, could be viewed as a hazard, that is a legal conclusion. What's odd is that they claim that it's a legal conclusion to say could, and yet they're relying on exactly that, claiming that's what the federal cases say.
Counsel, is there any dispute as to whether the flashers were on or the cones were out in this case? I mean, it doesn't sound like it from that response. Is there any factual dispute?
There is not.
Okay.
I believe there is a factual dispute as to whether there were 3 flashers and the actual distance, because there was only evidence from the CERT team that there were only 2 flashers that they found on the scene. But as far as the 3rd flasher, there is not. Now, as far as the distance and the visibility of those flashers and the visibility of the tractor trailer, that is disputed. And that is exactly why we're relying upon Mr. Reddick. But also, we have an expert that's in the record that the report shows that basically it is a hazard to have this tractor trailer on the side of the road. And in this industry, in the tractor trailer industry, everybody knows it's a hazard, and you have to do everything you can to remove that tractor trailer from the side of the interstate. Here is a question of fact. And when you have a question of fact, the way I always pretend it is, if the jury found this question of fact, could reasonable minds differ regarding liability? The question of fact is, was this tractor trailer visible? We have testimony that says it was not. Given that, summary judgment is not proper. And given that, this case should be reversed. Barring no further questions, thank you all very much for your time.
Thank you, counsel. We will take this matter under advisement, review the record. We appreciate your briefs and your oral argument. may be dismissed.